this for June 1st at 2:15 p.m.
No, I'm not available on that day.
Okay.
We already moved some stuff on that day.
Okay, June 22nd then. Final pretrial will be July the 6th at 2:15 p.m. And trial date will be August 14th. And I don't remember the other hearing by Zoom or not. Do you have an email, computer, man, or phone?
I have a phone, but not a computer.
I can have her come to my office yard.
All right. Okay, let's do it by Zoom. Pre-trial. All right. Now, regarding the other case, 22098, pre-trial, Ms. Collins is present by Zoom, and Ms. Burns got the courtroom to mention with the client. The defendant is charged with 5 counts, counts 1 through 5, involving all misdemeanors and forfeiture. And this is set for trial on June 27th, so this is the first pretrial. Final pretrial will set for June 1st, so we'll have to get a different date. We won't put that past the anyway. Looks like both figures have been provided, discovery, and you can finish any pretrial motions other than to reschedule the pretrial.
No, Your Honor, and actually we have already rescheduled that.
Okay. All right, and has been a written plea offer?
There hasn't, and I still owe the state discovery back, Your Honor. I don't have that out.
All right. That's due by final pretrial. All right, anything further than on that case?
No, Your Honor.
All right, thank you.
Your Honor, that first pretrial was moved from June 1 to June 22.
On the new case, yes.
Okay, thank you. Thank you.
All right.
Your Honor, Nancy was pictured and printed on the 98 charge. Does she need to do that for the new charge also?
Yeah.
Okay, so you have to do
Every new case has to have a booking.
that. Wait for that.
All right, Stephanie Fleming. Stephanie Fleming, attorney here in the jail. All right, this is case number 210162. State of Ohio versus Stephanie P. Fleming. Ms. Fleming, the attorney, is Patrick Hafner. She's appearing by Zoom. Also, the prosecuting attorney, Ms. Collins, is appearing by Zoom. In a matter of court status conference, I've been presented the plea of guilty form. Now, this happens to you, your client both waive for personal appearance before the court and be able to conduct this hearing with Zoom.
I do, but right now, something else has come up. Right now, just a minute to talk before the breakout room.
Well, actually, it take several minutes. I can go ahead to a sentencing that Mr. Armitage here on.
Okay, that'd be great,
All
thank you.
right? All right, I'm going to put you into a breakout room then, Ms. Fleming, with, which will give us your own time. Go ahead to Mr. Spring, Sloan. Sloan, Mr. Sloan here, okay. So I'm going to put you in a breakout room, Ms. Fleming, and it's going to come up on a screen, join breakout room, there's a button, and you'll need to click on that. And then you and your attorney will be talking alone. No one else will be able to hear you or see you. And when you're done, there's a button that says leave breakout room, and you just click on that. And while you and she are talking, I'll be doing the sentencing hearing. So, and 10 minutes. All right. Slow someone up that seat.
Josh, come on up here and see.
All right, this is case number 21 CR 206, State of Ohio versus Joshua Sloan. Sloan is appearing in court with his attorney, William Armentrout. The appointed attorney is actually appearing by Zoom, but we also have some Zoom hearings scheduled this morning, and so Armentrout is here. The defendant has entered a plea of guilty to retaliation, a third-degree felony. Matter was referred for a pre-sentence investigation. The court has received that. Each of the attorneys received a summary.
Yes, Your Honor.
Yes, Your Honor.
All right, Ms. Collins, anything on behalf of the state?
I only was contained within the plea agreement, Your Honor.
Armentrout?
I would ask the court to file a plea agreement and place Josh on community control. Having reviewed the pre-sentence investigation, I was, of course, aware of his misdemeanor convictions, but in reading this, it's pleasant to read it. He actually did what he was supposed to do. It looks like he's almost completed his drug counseling, has opted on his own to continue with that. He's fully employed. I believe that he would be a candidate for community control. I would ask the court to so order.
All right, Mr. Sloan, is there anything that you would like to say?
No, Your Honor.
The victim of this offense, Ms. Collins, was in agreement that the defendant should get community control.
Yes, she was. Yes, she is in agreement with that. We spoke with her back on February 28th.
Well, Mr. Sloan, court had a little skepticism about this plea agreement, quite honestly, when I read it, when I accepted it, and that's one of the reasons I want to mention that so it's not binding on the court, because retaliating against a police officer is particularly egregious offense, in my view. And he made a lot of really serious threats. Reading the summary, it does appear that she was high and either drunk or on drugs and acted like a fool. And that context is such that it didn't appear that there was any real planning about it. You just spouting off. Although I did see that in the truthful record, you got previous assault with a peace officer, and that's concerning. But there is a good report on you from the FRS, or meeting that you have, as Mr. Armstrong said, been doing what you're supposed to do. I'm not too crazy about your THC medical marijuana part. Medical marijuana, in my opinion, is just a legal scam that the state has adopted regularly because people complain about the very things that they have, and therefore, smoking pot helps them relax, blah, 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 blah. There have been exhaustive studies conducted on the medical effects of marijuana, and to date, there have been no scientific studies that have validated it. It's just that, in my view, and many other people, particularly in the treatment community and drug court community, that it's just another way to self-medicate when people are not using amphetamines, opiates, cocaine, different things like that. But at this point, you're managing. So I'm going to give you the benefit of the doubt. I'm going to order this to be put on control for a period of 3 years. In the supervision of the probation department, these conditions to obey all laws, all jurisdictions, conduct yourself in all my manner of life, report and as directed, to be truthful in all statements you make to the probation department regarding your condition. Keep them informed of your residence, place, employment, all time, management, and change either without prior permission. You're not permitted to leave the state of Ohio at any time without prior written permission. You must have a copy of that passed with you when you leave the state. Do not enter upon the grounds of any correctional facility nor attempt to communicate with or communicate with anyone who's an inmate in any of those facilities without prior written permission. You're not to possess, purchase, own, use, or have under control any kind of farm, ammunition, dangerous orders, weapons of any other type. You're not to purchase, possess, use, or have under control any controlled substance, drug abuse. I have CBD oil and kratom in there for the same reasons that I just explained to you. Or any variant or analog of any controlled substance that have effects similar to controlled substance and drugs abuse. For any instrument, device, or thing may be to administer them, prepare them administration unless you have law prescription, copy of which you must provide for the 24 hours receipt. If you submit drug testing, whether it has requested, you're not to purchase, possess, use, have any control of any alcoholic beverage, or be present in places sold, may be consumed, even so otherwise lawful. You're not to associate with anyone who is a co-defendant, in this case, or has a criminal record, any member of the gang or the criminal group, or any person who could influence you to commit a violation of these conditions or offense. You may not actually date this order, marry or establish cohabitation in a common marriage type relationship with another person who doesn't apply in a pre-existing relationship, then new relationship, without written permission. You must support any contact with law enforcement and arrest, citation, conviction, or other charge violating the law not later than next business day after it occurs. You provide your supervising officer with financial information records so you're willing to pay these fines and costs due. If you are referred by the probation department for any further evaluation or assessment, any other kind of treatment, counseling, therapy, or other training program, we'll submit to that. If there's any programming recommended, you'll roll in this assessment. Pay the court costs of this action and agree to I made payment arrangements to do that. And there's no restitution, correct? Alright. We successfully complete the FRS treatment program and any recommended action here. Now, by being put on community control, rather than being sentenced to prison, you're deemed to consent or search without a warrant of the person, your residence, your vehicles, or any other property, place, vehicles, where you're found or that are in control of any time, any probation officer or an employee of the department. If you don't find imposed, your court cost is a subject order, and if you don't make those payments, the court could have that collected in the clerk's office by letting the bank accounts rate of earnings. That doesn't affect the 10 o'clock. The court may order you to service to be correct each hour work, and not rate set by the court each hour work, you should have to find that amount to pay full. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file a notification in writing to the court so it's filed upon you. And if the hearing will be entitled to have an attorney, and the outcome of that hearing is that you have failed to comply, at that time the court will revoke your community control and sentence you to prison for 29 and 36 months, provided by law, fining $10,000. If that happens, once you complete the prison term imposed by the court, the adult parole authority could, at their option, place you under post-release control for a period of up to 2 years. If they determine during that period of time that you have failed to comply, they can return to prison. They can serve an additional period of up to 9 months for any single violation up to a maximum or half of your prison term. All violations that are committed as felony. Whatever sentence the judge in the felony case imposed upon that judge and also on the sentence in this case, the additional period of 1 year, whatever time left on that period, greater, that occurs, that may be served consecutively the sentence in the case. Alright, that completes the case. You're no longer on pretrial supervision, house arrest, etc. You should report down to probation immediately after court, so they can send you out for felony supervision officer to open the term. Any further counsel?
Hang on.
Alright, thank you.
Thank you.
I'm sorry? Oh, okay. Alright. Okay, back to right. Alright, we're back on record.
Come on.
Okay, we're back to record of State versus Defendant Fleming. The defendant or attorney had a breakout session now. We going to admit this after.
We are, Your Honor.
Right. Right now, Ms. Fleming, you're agreeable to this sentencing or this plea being taken by both testimony you during the jail rather than being present in the court. All right. Now, you are charged along with the co-defendant in 4 counts, first 4 counts of the indictment, 2 counts of aggravated trafficking, methamphetamine, 2 counts of aggravated possession, all of which are second-degree felonies. The court has received a plea guilty form that indicates you're going to plead guilty to count 1. Now, this is a form that the prosecutor's office prepared from their computer, and I'm going to hold this up to the screen for you to look at. And this is the first page has your case name, number, and plea guilty form. See that there? You recognize that form? Pardon me? You recognize that? Okay. And on page 2, page 3, at the bottom of the page, there's a sentence that says, I enter this plea voluntarily, and then there's a signature line, looks like Stephanie Fleming. And I'll hold that up to the camera as well and ask you if that is your signature there at the bottom of the page I'm showing you.
Yes, sir.
And do you recall when you signed this agreement, Ms. Fleming? All right.
Few months ago, Your Honor.
Okay. Well, I know there have been some, there's a period, I think this case was on inactive status for a while, so, have you gone over this agreement with your attorney before you signed it? You understood at that time that it was an agreement to plead guilty, and that that meant there would not be a trial, and the next step in your case would be a sentencing hearing?
I wasn't aware at the time, I'm not really sure the laws.
Okay, well, do you understand what's in this agreement? Have you seen the agreement recently?
Your Honor, we spoke about it, when I was screening at the jail, talked about it again, and I confirmed with the prosecutor that it was still a valid offer, since it had been a while, and then I'm going to read our breakout session. So, it has been a while since she's seen the agreement itself.
Okay. All right, well, all right. So, Ms. Fleming, you still want to go through with this plea agreement that you signed back in October?
If I can do rehab,
Pardon me?
rehab,
What about rehab?
like a rehab.
That's not my question. That's got nothing to do with what I just asked you. The question is, and this is a charge that carries a mandatory prison term. So there's no possibility of you going to a rehabilitation facility. It requires a prison term. It's no ifs, ands, or buts. I don't have any discretion. And that's what. And if you don't know that, then maybe we need to take a postpone your hearing so you can meet with Ms. Hacker again and go over it. Okay. All right. Well, I'll go through it. I come from an era when we didn't have plea agreements. We just did everything on the record anyway. We now have plea agreements because we want people to be able to read them and take their time to understand what's going on. So that's the concern I have here. So first of all, if you enter into this plea agreement, that means there's not going to be a trial. The agreement states on page 1 that you're going to plead guilty. Count 1, aggravated trafficking, methamphetamine, under section 2925.03A1, a second-degree felony. And under the law, that carries a prison term that's mandatory of between 2 and 8 years that is imposed by the judge. I can pick any number between 2 and 8. That's a mandatory number. You have to serve every day of that. There's no early release. You have to serve it. Now, under the law, that is the minimum sentence. The maximum sentence is half of whatever prison term is imposed, as determined by the Department of Corrections. So, if if you were to receive the worst possible sentence of 8 years, after you serve that 8 years, the Department of Corrections could decide that you should serve an additional period of up to 4 years. And that means that the possible sentence range for this offense then is 8 years minimum mandatory up to 12 years. There's also a fine of up to $15,000. There's a mandatory fine of $7,500 and a license suspension of 6 months to 5 years. You understand that? All right. Now, are you facing any felony charges anywhere else? Now, are you on probation, community control, parole, or post-release control, or felony from any other jurisdiction? All right. Now, under the law, as I indicated, this mandatory prison term, so community control is not possible. This is probation. That's been stricken off of the plea form that you signed. It's been stricken through the law. Now, count 1 alleges that on or about February 4, 2021, in Highland County, Ohio, you and Richard A. Duvalon did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding 5 times bulk amount, less than 50 times bulk amount, in violation of Section 2925.0381. So that's the charge. Now, do you understand what it is that you've been accused of having done, when, where, and how you did it? And you understand the possible penalties for that offense? And actually the mandatory penalties. Okay. You understand that it's a mandatory prison term offense. Right. Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise, possible possible outcomes of the trial with your attorney? And are you satisfied with their advice and confidence in this matter? Are you currently under the influence of any types of drugs or alcohol? Are you taking any prescription drugs? Antibiotics only? Okay. Those don't affect your ability to understand or communicate. Has anyone threatened you to make you plead guilty here today? Now on page 2, there's a language, I'll hold it up to the camera and show you. I'm going to read you this. See that language there? It's printed in bold and underlined. I'm going to read it to you. Can you see what I'm talking about? All right. It reads as follows. Defendant shall under plea of guilty to count 1. State will dismiss remaining counts. State defense jointly recommend 3 years incarceration. As consideration for the plea, defendant will cooperate, testify truthfully against co-defendants, pay back bond money in the amount of $1,310 to Highland County taxpayers. Now, is that your understanding of the plea agreement? Has anyone promised you anything other than that to get you to plead guilty here today? Now, under the law, Ms. Fleming, the matter of sentence is up to the judge, not the parties. So even though there's an agreement that you ought to get community control, the court has not found that. So if you plead guilty, once I've heard all the information that's been presented, if I decide that's not the correct sentence, I could impose any sentence that I think is appropriate between 2 and 8 years that the law permits me to impose. And you understand that? Now, do you hold any license or certification from any state governmental agency regarding that regulates any occupation or profession? All right. Now, you have certain constitutional rights you must understand before I can accept your plea. First, you have the right to have an attorney to represent you, and I appointed Ms. Hattner to do that. Now, that wasn't simply to work the case out, but to provide any defense that could be available under the law that you wish to provide. So, if you decide you don't want to take this plea agreement, that you want to defend against the case, she'll continue to represent you, including a trial. That's what you want. You understand that? Under the Constitution, you have the right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county that are subject to jury duty on your trial. They'd actually be selected, the evidence would be presented, they'd be instructed on the law, and then that jury would decide by unanimous verdict whether to state truth or guilt, or reasonable doubt. Now, and again, that unanimous verdict means all 12 of them have to agree. Now, in the event that she did not want to have a jury trial, that she didn't want to plead guilty, then you could waive the writing, which means give up, the right to have a jury trial, and in that case, you would have to always, bench or court trial, which means that instead of a jury hearing the evidence, it would be the judge who heard the evidence, apply the law, and decide whether or not to stay true to your proof beyond a reasonable doubt. You understand that?
Yes.
Now, under the Constitution, you have a right to confront witnesses against you in open court and to cross-examine for your attorney. What that means is witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps with your side of the case. You understand that? Now, under the Constitution, Ms. Fleming, you have a right to use the power of the court to compel or force witnesses to go to court to testify for you, just like the state. What that means is that the witnesses against you have to come into court to testify here in the courtroom in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence to help with your side of the case. You understand that? Under the Constitution, you have a privilege against self-incrimination, meaning you cannot be forced to give evidence against yourself at any time, including trial. Don't never make it testify. The prosecutor can't, the judge can't, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation, which is if there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, you cannot consider it for any purpose. You understand that? Under the Constitution, you have presumption of innocence, which means presumed innocent until proven guilty in the state of Ohio on every essential element of the defense charge. So you're not required to try to prove you're not guilty simply because you refuse to back up the law. You don't have to present any evidence in your defense. You may, but you're not required to. Whether you do or not, burden of proof will remain upon the state to prove your guilt and prove beyond reasonable doubt on every essential element of the defense charge, which is the highest burden of proof known under the law. You understand that? Now, originally you pled not guilty. Not guilty plea denying the allegations in the indictment as to all counts, denied committed any crime, and exercised or invoked all the rights I just described. You change your plea today from not guilty to guilty. That's the opposite of the guilty plea, not guilty plea. Guilty plea admits the allegations in count one, that's their crime, that you committed that crime. And that plea waives, gives up all of the rights that I've just described for you, except the right to have a jury trial. I'm sorry, your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives, gives up the right to have a jury or court trial. Waives, gives up the right to confront witnesses against you and cross-examine through your attorney. Waives, gives up the right to use the power of the court, compel or force witnesses to be in court to testify for you the same as the state. Waives, gives up your privilege against self-incrimination because if you say you're guilty, that's what you find you guilty. Waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you could have had up to this point in the case. Now, if I should sentence you to the maximum sentence, or under other circumstances, you can file an appeal. That appeal would have to be filed within 30 days of your sentence and entry being filed. You understand all of that? And are you a U.S. citizen, Ms. Fleming? And are you entering into this agreement to plead guilty voluntarily? So despite the fact that you signed this document back in October, do you understand what the terms of the agreement are today? And you still want to go forward and plead guilty in accordance with that? Do you need to talk to Ms. Hampton about anything else before we go any further? All right. All right, you should get the message there to hit the button join, and when you're done, hit the. And Mr. Kramer, you're there at, or I'm sorry, that's Mr. Taylor, you're at the start. All right, as soon as we get done with this other case, Ms. Hampton, your attorney, will do your pretrial so you can get back to your program. Yeah. You're back? All right. That's good. All right, we're back on record. Now, do you have any questions about anything I've explained to you here this morning, Ms. Fleming? And then it's your decision to go forward, plead guilty to the plea agreement pursuant to the terms that I've discussed with you here on the record this morning. The answer to the charge of count one was alleged in on or about February 4th, 2021, County, Ohio. You and Richard and A. Kugelon did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance of amount equal to or exceeding 5 times bulk amount, less than 50 times bulk amount, violation section 2925.0381. A second degree felony carrying a mandatory prison term of a minimum of 2 years up to 8 years set by the judge, with the possibility of whatever term is set by the judge being extended by up to 1/2, 50% by the parole authority, or by the Department of Correction. A fine of $15,000, a mandatory fine of $7,500, a possible life suspension of 6 months to 5 years. How do you plead? Right, the court finds on this day of the court, defendant provides of all constitutional rights, meaning knowing and intelligent voluntary waiver of the same pursuant to Rule 11. Please accept and order to file. The defendant is found guilty of count one as charged therein. Counts 2 to 4 are dismissed as to this defendant. Now, the agreement indicates that the request for pre-sentence investigation is a mandatory sentence. Is there really need for that?
There's no reason.
Okay. All right, and then the court then will proceed with sentencing forthwith, and not order a pre-sentence. Ms. Collins, anything you'd like to say?
Your Honor, I would ask to follow my recommendation that one of the have prior conviction because these charges are serious because of the hearing for the prison crime. She's been prior to the terms of the pretrial supervision. You did take the fact earlier this morning that I will not be seeking an indictment for failure to appear. She hasn't been in court in this case. Gosh, maybe back in November. She was pregnant at the time. During the time the case was pending, was tested positive. But I did also advise the time that we arrested this woman on her outstanding warrant. We searched her hotel room where she was staying and found four suspected men as well as men.
Which is not part of the agreement.
No, it's not.
And you agree that has happened?
I do.
Right.
Mrs. Collins, I did have a discussion about this.
All right, so Ms. Fleming, you understand that there won't be any indictment sought for failure to appear, but there could be another indictment for any drug charges if testing results show that what they found. So that's what they said they found was controlled substance. You understand that? All right. Okay. Ms. Hapner, anything you'd like to say?
Thank you, Your Honor. Originally, I have we'd asked for this investigation because this woman was pregnant and something were required to live in prison center. Obviously, at this point in time, she has given birth. Her baby is approximately 3 months old. And she would ask that she have the opportunity to see the child before she is shipped off. So we would place that.
Hey, Ms. Fleming, anything you would like to say? You're not required to say anything, but I'll listen to your client to say. All right. Well, Ms. Fleming, you don't have any previous record, and that's a good thing. But unfortunately, when you decided to get involved in criminal activity, you went for the big time. You didn't mess around with it. You went line of lead, you went right to majors, and committed a major legal offense. And, it's very serious under the law, are to be sentenced to prison, okay, same life. Your behavior since the charges indicted were on bail, not been very good either, and quite honestly, typically, in a matter like this, I would probably take that into consideration and impose a sentence beyond that which is recommended, because of the lack of cooperation and consideration for the court's orders. But since this is a mandatory offense, and it is possible that it could be extended by the Department of Corrections, depending on their analysis, because you have taken responsibility and you're also going to potentially face other charges on other matters, I will go ahead and probably agree in my sentence. So it's the order of the court that you be and are hereby sentenced to a mandatory term of 3 years of incarceration at the Ohio State Reform Court for Women at Marysville, Ohio. Now, that sentence could be extended by up to 1/2 by the Department of Rehabilitation and Corrections, depending upon their analysis of your case, which means it could be extended to 1.5 years or a total sentence of 4.5 years. Now, according to the sheriff, you've got 25 days of jail time credit. Picked up most recently on May 5th, released the next day, May 18th. And we're free of the courage, we're in jail twice in 5 days, and once in 2 days, for a total of 25 days. Now, upon completion of the prison term, whether it be the mandatory term that's required or any additional term that the adult parole authority may impose, it is possible that, or I'm sorry, it is mandatory that you be put under post-release control supervision under the supervision of the adult parole authority for a minimum of 18 months up to a maximum of 3 years. So you will be supervised once you complete prison term. No ifs, ands, or buts. By a parole officer, not by the court, of course, not involved. And if during that period of time you fail to comply with those conditions, they can return you to prison. You will serve the entire term set by the court for an additional period of up to 9 months for only a single violation, up to half of the prison term imposed by the court, which is 3 years. So that would be 1.5 years for multiple violations. And so that's the cap. However, if you commit a felony while under post-release control, then an additional sentence would be imposed by the judge in that new case. That judge would also sentence you for committing that violation while under post-release control in this case to an additional period of 1 year or time left on the post-release control period, whichever is greater. If that occurs, that had to be served consecutively the sentence in the new case. You understand that? Now, you're also ordered to pay the court costs of Judge Brandon execution's order. If you fail to pay those, or collect that for various means, including levy on bank accounts, wages, earnings, or other assets you have. That doesn't collect it, then once you complete your prison term, not while you're in prison, the court could permit you to do community service in this county and give you credit for each hour you work, an hour raise out of the court. Each hour you work will reduce your credit by that amount until paid in full. You're also ordered to make restitution jointly and severally to your co-defendant in the amount of $1,310 behind the county dashboard. That's a substantive order, so it follows you no matter whether you serve your police sentence or not, as far as an extended period of time of correction beyond the mandatory offense. And it can only be removed by either repayment or dying. So it can't be discharged in bankruptcy or anything like that. That's to be repaid through the victim witness escrow account, restitution escrow account, and you can pay any fees associated with that. All right. Is there anything further, counsel?
Did you waive the mandatory fine?
No, I did not. Given the fact that this is a mandatory sentence, that's in the court fine, she does not have the ability to pay mandatory fine presently, nor will she likely in the near future. Therefore, the mandatory fine is waived. All right, you're ran back to custody, ma'am. All right, we're getting Mr. Kramer. I'm going to go ahead and do Mr. Taylor from Stars of the pretrial. Justice Taylor, 22 CR 48. Alright, case number 22 CR 48, State of Ohio versus Dusty Allen Taylor. And you are Dusty Allen Taylor, appearing from the Star Athens video stream. Alright, this hearing is being conducted by Zoom since Mr. Taylor is 100 miles away. His attorney is Captain Hacker, appearing from her office. The prosecutor, Collins, is appearing from her office. Bench charged with breaking and entering theft, 2 counts of theft, 1 fifth degree felony, 1 a first degree misdemeanor. This is a, I believe it's for pretrial, final pretrial. Okay, we have a separate video. Okay, we have a trial date set June 13th. All right, now is discovery complete in this case? Yeah, I think you're finding this happened in 5 all years. Just
Yes, Your Honor.
and there's been no pretrial motion that I see. Is that correct?
There's not, Your Honor, we've received an offer, and I will take full responsibility for this. My office now, the plea offer and the discovery to Mr. Taylor, unfortunately, my gas mentioned some address in Clarksville. I did not realize that until just this morning. So I believe we'll have this resolved, but if we could just have another week so I can actually get it to him.
All right. What we'll do is I'll go ahead and wait the 14th day. I'm going to be available next week, but we can get it worked in after that, and we do it on Zoom, and if necessary, we'll vacate the trial or continue the trial date. Right now, I'll just leave it on and get information in, talk with him, and if you get a resolution, contact the assignment commissioner for scheduling the date, and we'll do a hearing by Zoom.
Would it be possible to do this in a breakout room while you finish up?
Absolutely. All right. Anything else from counsel in this case, Ms. Collins? All right. Okay, I will that close and reschedule here.
Thank you.
Okay, great. All right, there should be a button there, Mr. Taylor, if you push it says joint breakout room. There we go. All right, are you Harold Kramer there at the jail?
Yes, Your Honor.
All right, case number 21 CR 48, State of Ohio versus Harold J. Kramer. Mr. Kramer is appearing by Zoom from jail. His attorney is Danielle Witt. She's appearing by Zoom from her office. Representing the state from her office is attorney, prosecutor Attorney Collins. Ms. Witt, you and your client both agreed to conduct this sentencing hearing by Zoom remotely rather than in presence, in person appearances of both.
Yes, Your Honor.
You're agreeing with that, Mr. Kramer?
Yes, Your Honor.
Your Honor, we have a discrepancy in case number. You had 48.
I'm sorry. His case number is 21 CR 201.
There we go. All right.
I was referring to Mr. Taylor's
Okay.
number by mistake.
Thank you, Your Honor.
All right, thank you. All right. Mr. Kramer has entered a plea of guilty to breaking and entering under 2911.13A, a fifth degree felony. The matter was referred to the probation department for a pre-sentence report. Also referred to the drug court office coordinator, and I have a letter from Sturgill indicating that he has screened him and he appears to meet clinical criteria. We also have an application in the file that he signed requesting to be admitted into the drug court file. Now, I also received the pre-sentence report, and each of the attorneys had an opportunity to review the summary.
The state has, Your Honor, did not review, Your Honor, but I did discuss the findings of the probation department this morning.
Okay. All right. Anything from the state?
Yes, Your Honor, the state is recommending the defendant be sentenced to a term of incarceration of 11 months. You would first note that the victim does not approve of this defendant getting drug court. You would next note that the defendant has 4 prior felony convictions. And committed this crime, honestly, he must have been out of prison about 5 minutes because June 25th of 19, the defendant was both revoked and he was sentenced to 30 months in prison. And this offense was committed on November the 7th, 2021. So he must have had some good time credit or star or something like that, and was released and immediately committed this offense. He's been disbarred on at least 2 prior occasions. Crimes are not solely drug-related crimes. For example, in 05, felony 3 burglary, he was given 3 years of control for. Then a trafficking heroin, he was given community control, violated again, ordered to be starved, violated again, and then was for some reason just given 60 days in the county jail. At 19, an illegal conviction and active possession of drugs, 2 years community control, violated, revoked, 30 months in prison, got out, again, like I said, about 10 minutes bigger than this crime. You would note that, again, there are victims in this case, and they did not include consideration for drug court, either this state. We are asking this defendant to return for incarceration. Thank you.
Sweat.
Yes, Your Honor, we do ask the court for consideration of drug court, while as the comment stated that Mr. Kramer does have a history. It is my understanding that the co-defendants in this case did receive community control, at least 2 of them that I'm aware of did receive community control with that. And admittedly, when I spoke with Harold, he talked about how excited he was for this opportunity to change his life and to start clean and to break free of this cycle. As Tom stated, he does have a history and he has no problem serving the prison time. However, feels that it would be better suited to actually have a support system such as drug court and looking to fix his life instead of just band-aiding it and repeating the same cycle over and over again. But I'll let him speak.
All right, Mr. Kramer, anything you'd like to say?
Yes, Your Honor. First, I want to apologize for being in front of you. I did get out of prison when I got 5 days in my father had passed away in 2019. In 2017, 2019, my father passed away. It just, everything went downhill from there. And given the opportunity, Your Honor, I have been a 23rd recovery counsel in Waverly. Given the opportunity, I would not let down, take work, I would finish working and finish my rehab and do everything I can to stay recovered and stay in recovery community.
Okay, let's see, Mr. McKee was one of the co-defendants, and I think he had other cases before the court. Was he given control?
No, he was not. He was sent to prison. His other case was started to appear.
Right.
So the people that were given community control have no prior felony. They're listed.
Okay. Mr. Van Goos?
Yes, as well as the female.
Yeah. Got her name, I don't see it here.
It's Salon.
Oh, yeah, I remember her name, yeah.
They have no prior felony convictions, so they're possibly 6 terms.
Well, Mr. Kramer, one of the things that I noted in the probation report and interview says that you have a good history of complying when you're locked up, but not when you're not you're out. And this apologist went over that. Now, if you had a 2-year period of sobriety and your father died, you know, I'm so tired of hearing people complain about relapsing because of death. I understand my wife died in December, I didn't get drunk, to start using drugs. You know, it's an excuse. You know, I mean, I know it's a stressor, but there are ways to deal with that. And if you had just relapsed and the drug offense possession charge, then I would feel differently. But it doesn't give you carte blanche to go out and steal from people, break into their places, and victimize people. And you know, I just don't find that. And because you had, when you say your father died 2 years, well, this semester, over 2 years. So you had plenty of time to deal with that tragedy. So to come here and say that, you know, the death of your father 2 years ago still caused me to commit crime in 2021, you know, I'm just not mine. Just not mine. Right. So it's a judgment over the court that should be sentenced to the correctional center for a period of 9 months. You get credit for this is a mistaken thing. What day was he arrested? Were you arrested March 30th?
Yeah, I was home around County for 5 days.
So was that the 30th where you were arrested in Brown County? Is that the day you got here?
I believe that
It was, they so arranged on that day.
So you had 4 days in Brown County?
yes,
I did, so that's just 20 days, not close to that now, so March, okay, so we're gonna say March 26th, they have 30th. That'll be 5 days in March, 30 in April, 18 as of today, in May. So that's total 53 days you're gonna find credit. Now, upon completion of this jail term, it is possible that adult parole authority will put you in under close release control for a period of up to 2 years. They don't have to. Again, if they do, supervise the term they set by a parole officer, and if during that period of time they determine that you have complied, they can return to prison, making sure that there's a period of up to after the prison term for one more violation, but committed felony. And in addition, whatever sentence the judge in the case of closed felony, that judge is also authorized to sentence you for committing that offense while under close release control in this case, for an additional period of 1 year, or whatever times that on close release control is greater. That occurs, that has to serve consecutively the sentence in the case. You're also ordered to pay court costs or judgment grant execution order. If you fail to do that, then the court could, or you do community service, you can credit for your work and earn a rate set by the court. Try your work, reduce your judgment by that amount until paid in full. All right, is there anything further, counsel?
Yeah.
All right. Any other hand discussion? All right, I believe that's it. I don't have anything.
We have Mr. Williams here, 10:30, 10 a.m.
I was just gonna let you know, Dustin Taylor, I did the breakout room, we have resolved the case, this is set up for a hearing.
Okay, good. All right, thank you. All right. Okay, I believe that completes our Zoom session.
Yes, Mr. Williams, 10 a.m.
Yeah, 10 a.m.
Yes.
That's in person. Yeah, he's here.
Okay.
All right, I believe that completes the Zoom docket this morning. All right, we'll take a break here.
Okay, please rise. Have you met with your counsel?
Yeah.
Okay, he's out there. Okay. Have cell phones on you? Okay. Ready? Come on up, have a seat here. Stand. Or you can stay standing. That's it.
One thing that you come on the butt.
Is it gonna call ramifications next?
Yes, sir.
I've seen it, brother.
He said our pews aren't too comfortable. Stand. We're good.
Oh, is that right?
Yeah. I'm all right with it, I'll make it.
Hey, Dan, this is,
All right.
in a minute.
She must think that I can learn how to. Okay.
Please rise.
Okay.
PSI, 15,245.
This is the link right now.
Yes, sir.
All right. Case number 15 CR 245, Stableheim versus Brody Williams. The state is heard represented by Assistant Prosecutor King. We're going to have defendant is trial. Defendant was convicted in this case by trafficking and drugs placed under control on December 9, 2015. For 3 years. It was terminated successfully on June 13, 2017. The defendant has filed an application for leave of disability, which I believe actually, in terms of not mistaken, is supposed to be on civil procedure. In the county in which the defendant resides. Does he reside in Hunt County? Yes. Okay. I'll weigh that, see if we need that, in the future, and I want to take a look at the statute. So we have certain these, it's actually considered a civil procedure. All right, Mr. Armstrong, wish to speak to the.
Then we submitted on the motion stated Brody, the court just pointed out, has successfully completed his probation. It's my understanding that you can't be on probation for something the offense resulted in you losing your gun rights to begin to have been his felony conviction back in 2015. I would state that he is considered on probation now for a physical control charge, but it's only until his fines and costs are paid, so he still owes some fines and costs out of county court. I don't believe that's an impediment to these rights being granted. He wishes, if the court has a different opinion, I guess I would ask that this matter be continued, because I think we're in a position to pay those off and terminate that probation. So the court think that's definitely we can deal with that. Beyond that, his desire is to be able to basically help his son, Your Honor.
Okay.
State has no objection to the application, Your Honor.
Been any further that's other than the OBI?
No criminal offense, Your Honor, no.
Well, I don't have the statute in front of me, so what I'll do is taken under advisement. And you want me to file a memo to set forth whether or not there's any authority on that proposition. And barring the current probation issue, or grant that, but it needs to be held until he gets that paid off. And under law, the way they operate out there is you're under probation. And here we terminate you with let the clerk proceed flat. But they keep them open out there for a long time. I feel like going on with that or something. But anyway, it's still a valid probation order. I have some reservations on what I can grant until that expires. So what the remedy would be is on proof of the police and the police signed order.
I didn't look at any case law. I did review the statute yesterday, and it did appear to me that that's what couldn't be on probation for what college of your rights to begin with. It didn't talk about anything, any other probations, but I'll see if there's any cases.
Okay. All right. Thank you. Okay, Wesley Howard. Next, you need for all right, this is case number 220117, State of Ohio versus Wesley A. Howard. Mr. Howard, President of this council. Now, there was actually a superseding indictment issued on this case in May. You have a date you're supposed to appear for it, son?
No, I was going to pick the summons up right after I left here.
Okay, all right. So you have to receive that. You'll have your, I think we're already people on that line. Forget what it is. Schedule that's time off the line. All right. So this matter sets the trial, I believe, in July. After they created this trial, the person, and the branch was filed a motion for all. Address that matter.
Good morning, Your Honor. Judge, I'm respectfully requesting the court to allow me to withdraw from this case at this time. I believe that there are professional reasons, differences between myself and Mr. Howard that make my withdrawing necessary.
What would those reasons be?
Your Honor, I don't believe that it would be appropriate for me to list those on the record or discuss those with the specific of the court at this time. I think that there's an actual consideration of Mr. Howard that would prevent.
Well, I mean, is a difference of opinion as to strategy or defense growth or what? Is it something of that nature?
Defense approach, perhaps, Judge.
Here's what I'm getting at. Defendants have a right to have effective assistance counsel. It's constitutional right to have. There is no similar amendment that applies to attorneys. Attorneys don't have the right to have the effective assistance of their clients. And if they have a client that's not listening to them, doesn't want to follow their advice, wants them to do something that's recommended against, that's not sufficient reason to withdraw in this court view. So that's what we're getting at. Is that what the situation is?
It's not just a situation of of Wesley not being inclined to take advice. No, sir. There's more to it.
Well, I don't know how I'm going to grant something on when I don't have any evidence. I mean, you're going to have to give me something. Because we got a trial coming up in July. Yeah, well, let me ask you this. Have you obtained another attorney?
I'm seeking counsel
Okay,
right now.
now.
I'm supposed to have a meeting with him this week.
And you have identified an attorney? You identified this attorney?
No,
You have a point. All right. And you have a means of employing counsel?
to talk to them.
Pardon me?
To talk to them, yeah.
Yeah, and have, maybe told them what the trial date is and it's not
Yes.
going to be continued?
Yes.
Because, that's the concern I have. I got this trial date, and we've got a whole bunch of stuff going on, and I'm not,
I told him,
had a lot of issues getting this, so getting an attorney, and then ready to try it.
yes, sir.
Well, this time I'm going to deny the motion, subject to renewal, on the basis that he's seeking counsel, and if he does obtain counsel, I'll grant it. But if he doesn't, then at that point, Mr. Rack, if you want, having camera hearing or something of that nature, then I'll entertain it. But I've got to have some basis of why you're, the withdrawal this far advanced case, because it's a complex case, and I have some questions later. I'll get another attorney. I'll be ready in 6 weeks for this big trial. We've been talking all along about how difficult it was. There was a lot of evidence, a lot of time, so, I need to see some compelling reason why it's, not possible or not going to be before. And you represent vigorously and, forcefully and confidently and, reason this going to allow withdrawal unless you get your counsel. Or there is a reason that under the law would fail the court to allow you to withdraw, and that has to be in the record somewhere. So at this time, it'll be another. All right. So, you get your back next week. We're going to get there's a limited date on that.
The arraignments,
Actually, I'm going to be able to hear. Maybe in here in the, oh, yeah, it was yesterday, 8:30. So, you can go get it today.
Yeah.
And, Mr. Rackford purchases that, I guess, you want to get it. Have you seen the indictment yet? The superseding indictment?
No, sir. Frankly, Judge, I was surprised. I met with Wes a couple of Fridays ago. I was under the impression that the superseding indictment would have a different case number.
No, superseding indictment was in the same case.
It does in this county, but it doesn't in others, which is my
I've
guess.
been in other counties that does, but some don't, so it depends on practice.
So, my understanding at the time was that there would be a new case number. I know that there's new counsel now been appointed for the co-defendant, and for that reason, frankly, I had no intention of designating under what I thought was going to be a new case number. So that's my mistake, and I apologize.
And, well, I mean, you want to get a arraignment date set up after you fix up the indictment, you look at it, or you want to just go ahead and waive, you gotta ask her, so. If you want to go get the indictment, look at it, come back, and later, do it, or you can set it up as a, but you need to go get it, because, I'm not going to violate your concurrence, because the next time you get a, I mean, have this happen here, you get something, you need to figure out quick. Some of you guys have a good appearance on their, trial days and so forth. And,
Judge, is that what does the sheriff's office or the clerk of court have as indictment?
sheriff has the, service for it.
Does the,
unless,
the capacity,
Certainly.
see the ability to bring it here to the courtroom?
We can actually get a copy and have one on bailiffship with deputy service.
I'd ask them to do that.
Let's do that, then we'll take a break.
Unless they may have converted that, Your Honor. Since the Raymond's were yesterday, they may have converted that to a warrant.
No, I had to sign it over on that, that was just yesterday. So, just, I've been good at it. I mean, I don't have anything else unless so we have time, so we'll wait on that. I haven't looked at it, I don't think, I thought what they were doing was adding the, individual count, they had consent to the, case, and then maybe the ones that they were talking about that were charged or. But I don't know. Then we did observe that we did get something for bringing yesterday, superseding indictment, so. Yeah, and then we're gonna get clerk issues, new papers and, serve him and bring in a few minutes. So, okay, so we'll take care of that.
Please rise.
How you doing today?
I'm not too bad. How about you?
Well, same. It's a little chilly out there.
Could be any better off if I could run the court.
Yes, sir.
Summons reissue for prosecutor with correct case. 64 is the old case.
That'd be me.
117 is the new case. Find out from the judge. We don't want to he's already had it done, but I just say with loose charges, going to have his permission. Pardon me? That's what the judge wanted to send up here so he could review it. He's here for.
William Jordan. They're bringing him from, that's the sheriff's department.
That's not till 1 o'clock.
1 o'clock.
1 o'clock.
Are they bringing him here?
Says this to be, he'll be, according to the notation that the assignment commissioner puts on here, he will be doing a Zoom computer hearing from the jail, but he will be brought back to the Highland County Jail for that.
Okay.
But so he will not be in the courtroom.
Okay, is there any way they could let me see him?
Nope.
They won't let me see
You know,
him?
they don't even allow visits at the jail. You have to do it by video
Okay.
and Zoom.
So they're not gonna bring you?
Yeah, that's correct. If the notes stand, it's correct. It says be brought back from prison and be a jail Zoom, which means they'll bring him from whatever institution he was at to Highland County Jail, and then he'll get on the computer out there and be on the computer with the judge here.
Well, I didn't see him in a while, I just.
Yeah, I understand. Okay.
Thank you.
You're welcome.
That's crazy. You think they do it for that institution?
Well, they do sometimes, but and see,
Decades.
depends on what layer he's at now. He's at his final pretrial. So that means his attorney will want to sit down and talk with him, so they bring him back so they can do that. That way the attorneys don't bill for $75 an hour to drive to wherever they're in an institution. What case are you? Thought you'd been here a while. You got time to go get a burger or something? It's 10:45. You got 3 hours.
Thank you.
Yep. Sometimes you wonder why people are in trouble when they realize they can't read. Another one. I can't believe this. I'm going down through here and thinking that name's familiar, and they're all on today for other cases, previous cases. So we need that.
Which one?
111. We need 111. And he's supposed to be here too. He was here. He'd been here all morning. I said, "What case are you here for?" And he told me his name, and I thought,
Who's attorney?
he doesn't have any. But he's got another.
You gotta run down there again.
You want me to get it?
I'll get there.
I mean, I'll get it. What they gonna do here? Just go through it. Have you already been out to the sheriff's office and had fingerprints and mugshot taken?
For this?
I know you haven't for that one. But
Yeah.
for the previous one.
Yeah. The original 12 count in September, I did this.
Okay. Yeah. And you'll have to take that one out there and get it done again.
Yes, sir. So this is criminal enterprise now, October 10th.
No.
Oh, wait for it. Oh, let's go.
Alright, we're back on the record on state Howard. What was the on 64? I have now show that Mr. Howard had received summoned the copy indictment, is that correct?
Yes, sir.
Okay. You waived the indictment, Mr. Pratt?
Wes, do you waive reading of the indictment?
Okay.
Not guilty.
Okay. All right. Court then accepted not guilty plea. All previous orders, scheduling orders that have previously been issued will apply in this case to the superseding indictment as well. Subject to any further motions that might need to be filed or requested concerning the changes that were included in this new indictment. And so the same court occurrences and everything still apply. I don't know if we have any further pretrials or status conferences, but if there is a need for one, and or if you decide to make a motion, Mr. Rack, or see to get the attorney who does interference, and that's on there, Mr. Rack, right to withdraw, but you need to get on that real block after the best of the years. Right. Right. Thanks.
Please rise. Okay, Security. Good counsel.
Now, I just have one question. Because these was two different
should be taking the June 6th trial off the schedule because actually there should be a dismissal entry filed on that case number. There might even already be. He had this big case and he had a 10-10
Yeah,
case.
so-
The 10-10, there should be a dismissal entry and it may already be on there.
There was a bunch of papers inside the cover of this new indictment, and it said to replace indictment number such and such, so it's probably all in there together. So, and you received an assignment notice, something that looks like this, it had your name on it and the hearing dates and all that, you received that. As he said, all those dates are standing, okay, so make sure you have that. You're here, stay in touch with Mr. Rapp, let him know what his obligation is, but if you're gonna get another attorney, follow his direction.
Thank you, sir.
Thank you. Did they acknowledge they could hear you? They've got everything muted out there. Hi, this is Dan Cullen, Police Court. Magistrate Williams has a hearing set up on Zoom, or it's supposed to be a video conference with Spurlock. Supposed to be down in the video room, and I don't know if they've left it on Zoom from this morning or if they've got it set on video, but they can't hear her. Can you see them?
Yeah,
She can see the room, and there's somebody there in the room, but nobody can acknowledge us up here. Okay. All right, you're sending him up there? Okay. Okay. Yeah. Hey, this is Dan Cullen, Police Court. We are not getting anything from the video room. Okay. Magistrate Williams can see them, but they cannot hear her and respond to her. So if they could check it out. It should be in video mode. We're not zooming. There's no attorneys involved, so it's just a video conference. Okay. Can you hear us, LT?
That's why I'm talking to myself right now.
Can you hear us?
I said, I don't know what switch you guys got to bump up there.
Yeah.
What switch? Are you calling me?
Magistrate Williams is speaking on the camera.
Yeah, man.
We can hear you guys now, but I don't think they can hear us.
I'm sorry.
We can see and hear you.
You just walked up on the bench. Stand upside down. So the camera right behind you is the one showing the view. Ever been? No. Behind you, right there. There it is. Morning.
Well,
I say shut it down right back up.
I can hear her.
Can you hear me?
Through your guy, I guess.
Okay, okay, let's do this. Turn it off, I'll turn hers off, and we'll call you right back, okay?
all right, thanks. Too much technology.
This is just a 2-minute hearing. It'll take longer to log in.
Okay, I'll pause it since we're still playing.
So going back, then we're going to close up.
I've got this on video conference, correct? Civil.
This is just 2 minutes.
Zoom, use the address for this morning.
You wanna be there?
You called the shot chief.
Last hearing, jail hearing.
Use that same address. Give him that, you get out of the video, go back to Zoom. You just won't have any turn over to anybody else. We don't need him. We gotta Zoom this off meeting. I don't think it matters. I don't think it matters. I get to log into what we did this morning, as long as we've got it on the jab.
The judge didn't look at it from here. Who was it that?
Cases.
Are you doing, you cap versus the
EduCap Incorporated?
Here, criminal hearings all.
Yeah.
Start that right now. We'll go back into what you had this morning. Recording in progress.
We have Lathy, Fleming, Kramer, Sloan. Here.
Yeah, tell us the law check in. Where's now?
Yes. Are you on video conference?
I'm on Zoom. You want to go back to video?
There.
Can you hear us now?
I can hear you, but
We can see video, we can keep,
Can you hear me without the content? Can you hear me?
I can hear you, but you got the same camera we had before.
okay, so we're back to normal, right?
No,
It's supposed to be that
the
camera.
camera under, the one up behind you, man. Camera behind you, right there. Yeah, that's the camera showing.
We can see it.
I'll face that way, how's that? Oh, she can hear me. This is just 2 minutes here.
Okay, let me get us started.
Hold on, wait a second.
Are you ready, Magistrate?
We're on the record that Spurlock versus Spurlock, case number 09-92. Case before the court is a hearing that Mr. Spurlock is being held on habeas for non-appearance in a child support hearing. Mr. Spurlock, you were ordered to appear at the hearing on March 17th and failed to appear. Can you explain to the court why you didn't appear that week in time?
Yes, I was incarcerated in Clinton County. I wrote the judge a letter.
And you were just recently released from there, is that right?
Yes, I was.
And so, Mr. Spurlock, what is your current address? If you were released from incarceration, where would you be living?
74 Orchard Avenue, Sabina, Ohio.
And who did you be there with?
Just a friend. She's,
And her name?
it's Junior Hubbard's, Nancy Hubbard.
And do you have a phone, sir?
No, I don't, not at the moment. I did have one, I got incarcerated, but it's kind of lost now.
Okay, and do you know anybody's phone number that we could use to contact you if we need to?
Yes, yeah.
Good.
Are you ready?
Name and phone number.
Brandy McCord, and 937-302-8243.
Sir, if I reschedule your hearing for August the 4th at 1 p.m., will you show up for me?
Yes, ma'am.
I'm not going to write up to keep you in there until that very day if I want to, but if you give me your word, you're going to be here, that's all I want, I just want you to show up.
Yes, I promise, I'll be here.
Okay, so I am going to order that you be here on August 4th, 2022 at 1 p.m. on Police Court, Allen County. Okay? We'll send you,
Okay.
I'll send you a written notice out to jail, fax you a copy of the entry, and the signed notice, I want you to get that before you leave, once you receive that authorization. Any questions?
Okay. No, thank you.
Nothing further, we're adjourned.
You're welcome. And we're zooming. And
Right, okay.
on the record.
All right, this is, Educat Inc. versus Julie Smith, Sally Bowles, well, CV 100. This is a pretrial, not pretrial, being done by Zoom. And you're making Urban appearing, from your office, on behalf of the plaintiff?
Yes, that's correct.
All right, and, you are, it says Julie Freeman, is that your name now? Used to be Julie Smith?
Yes.
All right, so you're
Yes.
now, Ms. Freeman, okay?
Right.
Okay. All right, the matter of this case, is set up trial, June 14th. And there was a motion for summary judgment, court granted summary judgment regarding liability, but, since there had been a letter sent by this, Fryman, which she's not disputing liability, but disputing the amount, or didn't feel that there was sufficient evidence to grant summary judgment as to the damages, of course, did approve that. And what my hope was is that, Ms. Urban and Ms. Fryman, that you guys could talk, and, perhaps, the plaintiff would be able to provide the payment history and account to be able to demonstrate what's owed, so you do admit that you owe something, but not, you're not very to the amount sought. Now, has there been any conversation between the two of you?
So, we received a call with an offer which I reviewed with my client. They do have a counter offer which we tried to pass along this morning, but I haven't just.
Okay.
So,
All right.
I don't have any missed calls. I am at work, but I do not have any missed calls from their office.
Okay. What's your phone number? You're gonna get that to her so she has it right now.
740-851-2784.
Okay. All right. Well, I'll just. I assume what we're gonna have is an account and a witness to verify the account how it was conducted, and this. Freeman, if you have your own records that that would show that you made payments that were not properly credited, or if you have information or evidence that shows that the interest or penalty has been incorrectly computed or something like that, that's what I would be looking for in making that decision as to what is owed. And so, court can't figure it out on its own, has to rely on whatever evidence is presented. And so, if you have that kind of information provided to Ms. Urban, I'm sure that she'll provide it to her client, and they would look at it to see if they're acting custody. I've had no more than one case in which accounts were not acting over the years, state accounting. And sometimes payments are not posted the wrong accounts, or something like that nature. So, if that's happened, that's what things you need to be able to discuss. And if that kind of thing happened, I would guess that Ms. Urban and the client would agree if you showed that they made a mistake. If they disagree, then they explain it to you, and that perhaps you'll understand and look and see that what they're saying is correct. I don't know. But she's indicated there's a counter offer, so I don't need to be involved in that, but, you know, the two of you, we continue to discuss this, maybe can get worked out, or we won't have to have a trial, but if you don't, then we'll have a trial. Now, Ms. Urban had contacted the Science Commissioner inquiring about a remote hearing, and I do remote hearings all the time. If you two want to agree with that, I would need to have, you know, agreement by both of you in writing stating that you agree to that, and then the exhibits have to be pre-marked and given to me before, get it to me, because I need those in hand here at the courthouse so that I can look at them. They do need to have their own copies exchanged with each other, so everybody's looking at the same document. And if there's a witness that's going to testify remotely other than you, Ms. Brian, and also if have a plaintiff, then they would need to have a copy as well. So everybody's looking at the same thing. And you can do the screen sharing this, Urban, so that you know, you can show on the screen. But one of my, I've done lots and lots of Zoom hearings, and one of the things I found is it's really hard to follow exhibits on the screen. And also listen and see people, so it's easier to have the document here. I can flip back and forth at things quicker than I can with someone else controlling the document. So if the two of you want to discuss that, I would be more than happy to do this remotely and, you know, it's okay? All right, anything else, either like to bring up?
No, if Ms. Urban can speak now, I'm uncovering my tax return. We weren't able to get a.
Let me put you into a breakout room, and then I'll go ahead and leave the room and mute mine, and you guys are done, then we'll just leave the breakout room, and actually, I think I'll tell you what I'll do. I'll just leave it on. I'll turn down the volume, and I'll step off the bench, and then when you're done, they'll be disconnected. Okay? And when we do have the hearing, Ms. Brian, it'll be better if you're at a fixed location.